meeting of the Tennessee Real Estate Appraisers Commission. It was posted to the Real Estate Appraiser Commission website on October 27th, 2014. First thing on the agenda is to call to order. We've just done that. And we need to adopt the agenda as written here. Has everyone had a chance to review the agenda?
Yes.
Do we have a motion to adopt?
Second.
All right. We have a motion and a second. All those in favor say aye.
Aye.
Those opposed? No opposed, and it carries. Next thing on the agenda is to review and approve the October Commission meeting minutes. Has everyone had a chance to review those? All right, we've got a motion to accept by Commissioner Hall and a second by McCara.
Mm-hmm.
You know what, we did not have a roll call.
It's okay, you don't have to.
All right. So we've got a motion and a second to adopt the October meeting minutes as written. Those in favor, aye.
Aye.
Those opposed? And the motion carries. Next thing on the agenda is to a report of the experience interviews and recommendations.
Thank you. The experience interviews are on your iPads. I interviewed several trainees. The first one on your report is Joshua D. Stewart. His reports were compliant with USPAP, recommended improvements to support the effective age opinion, site of value, and summary of the reconciliation. I recommend approval of his experience request.
All right, we've heard Ms. Avers' recommendation. Is there any discussion? Do we have a motion to accept?
Motion to accept.
Second.
All right, we have a motion by Ms. Johnson, second by Mr. Hall. Those in approval, vote by saying aye.
Aye.
And opposed by nay. Motion carries.
Second interview was Sean Workman. He's requested to upgrade from training to certified residential. His reports were compliant with USPAP. However, we had some discussion about supporting his adjustments, specifically for gross living area. I recommend approval of his experience request.
We have a recommendation for approval from Ms. Avers. Do we have a motion?
So moved.
Second.
All right. The motion by Mr. McCara, second by Mrs. Point. All those in favor say aye.
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 Those opposed by nay. And the motion carries.
Next, two reports, they were interviewed together, Timothy B. Atkins and Christine Atkins. The reports were minimally compliant with USPAP. However, there were a lot of areas that had reporting issues, including summary of the analysis of the site value. There was a lack of support for the adjustments. These were discussed with both applicants at the same time. The supervisor had instructed both of the trainees to report things as such. However, they indicated moving forward as certified appraisers, this is not how they'd be writing their reports. I recommend approval of both of their experiences.
All right, again, we have Ms. Avers' recommendation. Do we have a motion?
So moved.
Second.
All right, we have a motion by Commissioner Standiford, seconded by Commissioner Point. All those in favor say aye.
Just
Oh, okay.
discussion.
Yes, sir.
Quick one. During these interviews, I noticed both of the trainees that
There were a lot of reporting issues. For one thing, they referred to themselves as certified trainees, which is not a real classification. They had a lot of report writing, lack of support for their adjustments, lack of summary of their analysis. In the site value, they had indicated an approach to determining the site value that wasn't how they actually determined it. They could describe it to me, and they supported it through their work file, but what their summary and their report said was not what they did.
on the adjustments, did they indicate that the supervisor told them what to do, or did they make their own adjustments?
They said their supervisor told them what to do, and their supervisor plans to retire as soon as they get certified. So, I wasn't
Now,
overly worried
reason-
about their
The
supervisor.
reason for me asking these questions is because I had a similar situation whereby the trainee was told what to put down, and they put down that number. They really didn't understand what they were doing. And so and at that point in time, I recommended they come back again with some reports they had done themselves that we could actually talk with them about. And I'm just wondering if we have the same situation here, or there are other extenuating circumstances that we would not be aware of.
They seemed knowledgeable to me. They seemed like they knew how to develop the adjustments. It just, they were sort of at an impasse with their supervisor as to what they would allow. Like, they would do the report, and their supervisor would change it back. So,
Savers, if you were me and this were a student or students, what grade would you give them? Okay.
What?
D as in dog, right?
they would have been barely passing. But again, I'm just checking for minimal compliance. They weren't great reports, but they were minimally compliant.
I was just wondering about that, because once again, I don't want us to be having two sets of grading criteria, not grading, but rating, I reckon, criteria, for the people coming before us.
That's one of the reasons why I put together that checklist, so that I would be fair to all the trainees I interviewed, so that, if there was an area that they did not comply, that I'd have to mark no. So I did a checklist for every single report I reviewed.
So the reports did meet minimal standards,
And I wrote
although
down,
they were not correct.
I wrote down any area where they needed to improve. Like, I wrote down discussion points and any areas that I had concerns about, and yeah, there were some analysis issues, or summary issues, but it wasn't so much the analysis.
You see that these two individuals have the ability to improve, and there's every reason to believe that they will improve their skills and knowledge and ability.
I think they will.
Their education would indicate that also.
I think so, yes.
Okay.
They have taken the new education requirements. They aren't applying under the segmented approach. They took the 2008.
I have no further questions.
All right, is there any further discussion? All right. We have a motion, we've got motions on the floor. All those in favor say aye.
Aye.
Those opposed, by nay. And the motion carries.
The next applicant was Lori Vest. Her reports were also compliant. Some of the report writing improvements and support for adjustments, however, overall, her reports were well documented, and her experience submission was well documented. I recommend for approval.
All right, we have Ms. Avers' recommendation on this trainee as well. Do we have a motion? All right, the first motion is by Commissioner, I'm sorry, I can't remember your name.
Thomas.
Commissioner Thomas, seconded by Commissioner Standiford. Is there any discussion on these? All right, those in favor vote by saying aye,
Aye.
and those opposed by nay. And the motion carries.
James Whittington applied to upgrade to certified residential. His reports were really well written. His reports were well supported. There was some minor discussion on improvements. It was sort of a best practices thing. He was a really good trainee. I recommend for his approval.
All right, again, we have Ms. Avers' recommendation. Do we have a motion?
So moved.
Second.
All right, the motion by Commissioner McCara and seconded by Commissioner Johnson. Is there any discussion on this training? No further discussion. Those in favor vote by saying aye,
Aye.
and those opposed by nay.
If that wasn't enough, I also threw in a 500-hour experience interview. Mary Kate Scott came in. She had really well-written and supported reports. We had some discussion about summarizing her analysis. She is gaining valuable experience and is off to a strong start towards licensure or certification. She's doing really, really well. No vote is required on that one. Thank you. That concludes my report.
All right, and was there one more trainee interview?
There was not. That person needed to cancel because they are taking a crash course for the test today. So I guess I will be doing that training. Hopefully Ms. Point and I can confer so that I can get the short version of what I need to look for on those reports.
All right, so that concludes the experience interview recommendations for this meeting. And we will move on to the education report, for which we'll recognize Commissioner McCara.
We've got, let me show that last one. There was another one added to the list that, I think it's on the, on your iPads. It wasn't on the hard copy, but we had 4 courses proposed, and then also for Commissioner Collinsworth for course credit attendance at the AARO conference and ASB meeting. And I recommend approval for all the courses and also for Mr. Collinsworth's attendance to the conference for credit.
There are 5 courses, just to be
5.
clear.
1, 2, well, you're counting Mr. Collinsworth?
No, there's 5 courses.
Oh, yes, excuse me.
I just
was
want to
looking
make
at the
sure we
hard
get them all
copy list.
approved.
Excuse me, I was looking at the hard copy list instead of, as I said, the one that's on your iPad. I recommend approval of the 5 courses, and then also the individual course approval for Mr. Collinsworth.
All right, we have Commissioner McCara's recommendation for the educational courses to be approved. Is there any discussion on this? If there's no discussion, all those in favor vote by saying aye,
Aye.
and those opposed by nay. And the ayes have it. Now we will...
I'm sorry, I didn't get that down. Who was the motion and the second on it?
I don't think it was ever moved unless you count my recommendation
Oh, I'm sorry.
as a motion.
Do we have a motion to accept?
So moved.
All right, we have the motion by Commissioner Point, second by Commissioner Standiford.
Got it.
And now, those in favor by saying aye,
Aye.
those opposed by saying nay, and the ayes have it. And we are ready to move on to the director's report.
Okay. The director's report should be on your iPads. It was a little lengthy this time, but I included a summary of the AARO meeting. On the first page, you'll find the fiscal close information for fiscal year 2013-14. Also, the incoming beginning of the year figures for expenditures and revenue for the program as of July 31st, 2014, which is all the information I had as of the date I compiled this report. Below that, I have the license status counts as to all of the certified general, residential, licensed, registered trainee. All of those figures have remained fairly consistent through the last several months, as have the appraisal management companies. Temporary practice permits, approved courses, also remaining consistent. Complaint count is on the next page. We have 7 in payment plan tracking, 4 pending formal hearing. We have 7 on the legal report. None pending consent order, and we have 7 under review. There's 2 out for request for response. There is below that a summary of the ASC Advisory Committee meeting. They met in Washington, D.C., well, actually in Arlington, Virginia, just outside Washington, D.C., and I attended that meeting. It's very intriguing. They advised the appraisal subcommittee on rulemaking. It's made up of regulators, appraisers, AMCs, and lenders, and they all make recommendations to the subcommittee members as to how they should adopt laws or adopt their rules pertaining to policy standards for enforcement of all of the state regulatory agencies. So like one of the requirements is that we process our complaints within 1 year. They also determine what sanctions they can enforce against a state. There's new requirements on that, and they have new enforcement powers, so they're making new advisory recommendations to the subcommittee. There's a photograph and a summary of the Standards Board meeting. That was one of the larger meetings I've ever seen of a Standards Board meeting. Usually there's about a dozen or so, but this particular meeting had 130 people in attendance, which has got to be a record. It was very well attended and had a lot to do with that exposure draft on draft reports. That was the hot topic. A lot of people are resistant to that particular issue. Persons who have worked regularly in the CG world are used to draft reports, but regulatory officials enforcing requirements for residential appraisers see it as a way of skirting the issue on record keeping and abuse for the residential world. If you can just call it a draft report and you don't have to maintain a copy of it, you can just, anything you said, oh, that was just a draft report, I can just shred that version. Here's the fixed version. We see a lot of potential abuses of that. So they're still working on it. I think there'll be another exposure draft, honestly. Then the AERO meeting began on Friday afternoon. We got updates from the subcommittee, the Standards Board, or the foundation, and the ASC Advisory Committee meeting chair. And we had breakout sessions for the hot topics. We broke into on Saturday morning, we had breakout sessions. One of the hot meetings was we had investigator training. We had one of our own appraisers from Tennessee give an investigator training on how to do skip tracing. That was really interesting. And then we had an administrator breakout on planning for disasters. So that was pretty exciting stuff. We had Tim Doyle from the National Mortgage Licensing System give a discussion on the NMLS. Magdalene Vasquez gave a presentation on CAP approval and how to use the Appraisal Foundation's website and what the backside of their website looks like, what goes into course approval for them. And then Sunday afternoon, I was sworn in as president. That was scary. And there's a picture of the swearing-in ceremony. On Monday, we had presentations from FHA, VA, Fannie Mae, RELS, ServiceLink, CoreLogic, LIA administrators. It was a really well-attended Monday, considering it was the last day of the conference. We had just about every seat in the house packed. I gave closing remarks, and that was the end of the Aero conference. Ta-da. Close my report.
Can I ask you a question?
Sure.
And this may be a dumb question, I apologize in advance, but was there any discussion, maybe this wasn't something you would all ordinarily discuss, but was there any discussion about the idea of the online courses versus in-person courses for continuing education and qualifying education?
No, that's, a lot of states already do that. That's a pretty common practice. About 40 to 50% of the states already allow online qualifying education.
100% online?
100%, or
Qualifying?
close to. You know, like some of them may require the USPAP class to be taken in classroom, so, you know, it's pretty close. And then for the continuing education, it's even a higher percentage. I don't know exactly what that would be, but I think it's probably closer to 80 or 90% of the states. So
And
it's
if
pretty
there was
high
any-
percentage rates.
If there was any kind of blowback about that people are saying, no, this isn't working, or we need to reconsider this, or questions like that, that did not come up, Ms. Avers?
Hasn't come up. It's pretty well established. For appraisers, we have to go through IDEC approval, which is not required for every profession, but for appraisal courses it is, which is a approval mechanism for the delivery method. That doesn't review the course content. And then, of course, we have the CAP approval for the course content, so that only leaves approving the course instructor. So as long as the course instructor meets the state's requirements, that's a course that's online and meets the IDEC and CAP approval, is pretty easy to review for consideration.
All right, does that conclude the director's report?
Yes, sir.
All right. Do we have a motion to accept?
So moved.
Accept by Commissioner Standiford. Do we have a second?
Second.
Second by Johnston. All those in favor say aye.
Aye.
Those opposed, nay. No opposition, the motion passes. And now we are ready to move on to the proposed rules for emergency rulemaking.
Okay, so you guys got a copy of the emergency rule filing. Hopefully you've read over that. The situation with this is, the soonest we could file the regular rules. Soonest we could have the meeting was January 12th, because you have to wait so many days after filing them with the Secretary of State's office. So that pushed us back a little further than we were hoping. So we decided to file emergency rules, which will cover us until we get the regular rules filed. I am confident about this. I think everything's going to be completely fine, because with emergency rules, once you file them, they become effective. So you don't have to wait the 90 days. So this will cover the lapse that we'll have while we're waiting on the January 12th meeting. These tend to move quite a bit faster, which is positive. The only thing that we have to do at this point is you guys just have to approve these rules as an emergency rule filing. So we'll just need to make a motion for that. We don't have to discuss anything unless you guys have questions at this point. We'll tell you that the online education portion is not included in these rules. I know that's kind of a controversial thing, so because those are not an emergency, we're just trying to wrap everything for the AQB January 1st, 2015 qualifications into this rulemaking to make sure that we're in compliance with those. So these are not as lengthy as the normal rules because some of them weren't really an emergency in this situation. If you have questions, we can try to answer questions, but I did want to let you know that the online education rules are not included in this. Those will come back around at, I think it's January 12th meeting. Yes. So we'll just need to have you guys approve these as an emergency rule filing, and then I'll need to read the statement of necessity into the record, and then you'll have to approve that statement as well.
All right, we heard Mrs. Gamber's comment on the subject. Is there any discussion? And do we have a motion?
So moved.
Motion by Commissioner Hall, second by Commissioner Standiford. All those in favor indicate by saying yea. Aye. Those opposed by nay.
Okay.
And the motion passes.
Okay, so I'm just going to quickly read the statement of necessity, and then we'll just need to get another motion on that, just to get this in the record. The Tennessee Real Estate Appraiser Commission is subject to the enactment of, are you good? I'm good. Okay, of 2014 Public Chapter 621, effective January 1st, 2015, which allows fingerprinting for any applicant for initial registration, licensure, or certification in order to meet statutory requirements set forth in the Act. The Tennessee Real Estate Appraiser Commission is subject to the provisions of Title 11 of the Financial Institutions Reform, Recovery, and Enforcement Act of 1989, which allows the Appraisal Qualifications Board to establish the minimum education, experience, and examination requirements for real property appraisers to obtain a state license or certification. States are required to implement appraiser licensing and certification requirements that are no less stringent than those issued by the Appraisal Qualifications Board. The board established new criteria that becomes effective January 1st, 2015. In order to be in federal compliance, the Tennessee Real Estate Appraiser Commission must establish rules to implement this criteria by January 1st, 2015. The implementation of these rules within the required time period to implement these rules precludes utilization of rulemaking procedures described in Tennessee Code Annotated Title 4, Chapter 5, Part 2 for the promulgation of permanent rules. So if we can just get a motion to adopt the statement of necessity.
All right. We've all heard the statement of necessity read by Mrs. Gamber. Do we have a motion to accept? So moved by Commissioner Thomas. Do we have a second? Second by Commissioner Hall. All those in favor say aye.
Aye.
All those opposed by nay. And the motion carries. And now we're ready for the legal report.
Okay. Item number 1 that's listed on your legal report, these are the matters that Commissioner Standifer is reviewing, and he is going to have those ready at the December meeting. Is that correct? Okay, so I'm going to read these 2 item numbers into the record, and then we'll just, I guess, make a motion to defer those to the next meeting.
Okay.
Item number 1, it's 2014014951 and 2014014952.
All right. These are still under review. Would there be any discussion? Are we ready to entertain a motion?
Make a motion, we defer to next month to get the review from Mr. Standifer.
All right. Motion to defer by Commissioner Hall. Do we have a second?
Second.
Second by Commissioner McCara. All those in favor indicate by saying aye.
Aye.
Those opposed by nay. And the motion carries.
Item number 2, 2014018351. This complaint was filed by an appraisal management company and alleged that respondent misreported that the basement was 100% finished and overvalued the subject property. The complaint alleged that the house went into default and the secondary market participant required the AMC to repurchase the loan. The AMC had the matter reviewed and found that not only was the basement misreported, but that the value opinion was overstated by approximately $100,000 per their field review. The original opinion was $440,000. The field review opinion of value was $346,000. The respondent indicated that her appraisal was conducted in accordance with USPAP, and she was not privy to any correspondence between the AMC and the GSC or the alleged repurchase of the subject property. Respondent indicated correcting the indicated finish to 68% would not affect the opinion of value. Respondent disagrees with the field reviewer's opinions and conclusion. The reviewer's conclusions are listed there, as well as the respondent's response to those conclusions. It is quite lengthy, so if you want to take a minute to just review those and then let me know when you're ready for the recommendation.
For a point of discussion for, Mr. Hall made a comment to me earlier. You don't have to adopt all of the bullet points. If you want to make a recommendation to remove any of the bullet points, you certainly may.
Has everyone had a chance to look over this case? Or do we need a couple more minutes?
A couple more minutes, please.
Okay. All right, how about now? Is everyone ready? Okay.
While the reviewer did find several violations, the basement bullet point and the adjustment for land size in the wrong direction are substantial errors that would affect value. The remainder are minor report writing violations. As such, council recommends this matter be closed with a letter of warning.
All right, I'm sure on this one that there's probably going to be some discussion. Do we need to have a motion on the floor first and then the motion and then discussion, or can we go ahead and discuss?
You can do either.
I'd like to go ahead and open the floor for discussion on this one then.
I thought the response was very good. I think that the person addressed the issues that was raised. Several of the items that they pointed out. Recommendation by council is appropriate.
Are there any other thoughts on this case?
If this is approved, do these bullet points and all of these items go in the record as such, or is this just a general?
Yes, normally all of the bullet points would go into the letter of warning unless the commission takes out what they deem necessary.
So you would include all these bullet points, even though they're not applicable?
If the commission doesn't want to adopt a specific bullet points, all they have to do is include that in their motion to remove whichever specific bullet points, and then we would amend the letter of warning to not include those.
And the reason for that, just so you know, is I'm not an appraiser, so I feel like I can't really go through and pick and choose on these bullet points. That would be something that you guys would have to instruct me on. So if there's something that you don't think is applicable and you want to take it out, then we'll just do that right now.
And I reckon my question goes back even to the beginning of time. I wrote them a letter on this thing, closed with a letter of warning. I reckon I was not clear what went into that letter, other than saying, hey, you know, this thing was filed, we reviewed the allegations, reviewed your response, and the commission recommends closing. I was never aware, if I was, I stand corrected, that we would actually list every one of these bullet points in that letter that goes back to them. If that's the case, even on these things, then we should be a little bit more specific, even though they answer the questions that are raised in the bullet points.
Right. Yeah, if that is the case. So if there's something in there that you don't think is appropriate or applicable, then we need to go through there and take out what you don't think is necessary.
So
The only reason that we wouldn't list the notice about the violations in the letter would be if you just close it all together. That's the only way that basically none of these make it in there. If it's closed, it's just closed.
brings up a whole new can of worms, in my opinion.
What's the,
Because without seeing the actual appraisal report itself, how do I know whether these bullet points are applicable, especially when the respondent says they're not? And out in front of us. Now, realize we've been hammered on the legal standpoint is you can't know. You got to make a judgment with not knowing the facts. I've never liked that idea. Don't like it now, never have. But I don't like the idea either of sending out these bullet points, having not actually seen the report itself and having to rely strictly on what was here in front of us, especially when the response addresses these points and says, no, that's not right. This is what I actually did. That's incorrect. And we have seen that happen on numerous occasions.
A letter of warning,
Very concerned.
A letter of warning warns the appraiser not to engage in specific violation behavior. So that's what the letter of warnings are for, is to indicate to an appraiser that a violation potentially has been found, although not proven. So it's non-disciplinary, but it is noted.
It doesn't state in a letter of warning that you committed this, and this, and this. I mean, I don't know if this is going to make you feel better, but instead it's more of, we wanted to caution you as to these things. Not that we think you did this, and this, but still, I mean, if you have an issue with it, then we should definitely go through and take out what you don't think works here.
Let me ask you a question out of ignorance. What happens to this information? Does it go on somewhere else?
If it's a letter of warning, then the information just goes into the file, but it's not listed on
And
it.
where is that file kept?
They're retained in the records of the Tennessee Real Estate Appraiser Commission office. I mean, a letter is communicated to the respondent in
These
the
bullet
case.
points and so forth, are they kept as part of the record?
Yeah, the legal report, well, the minutes of the meeting is kept in the file, not the legal report itself, but the
Who has
minutes of the
access to
meeting.
that information?
The minutes? Everyone has a
Everyone
copy,
does.
has
Okay, so
access
everyone would
potentially.
have access to these bullet points as well, is that right?
I mean, you can get access, our minutes are posted to our website, but the file, you have to make a public record request. You'd have to know to go looking for it. It's not like, you know, we publish out there, hey, John Doe has 6 complaint files. You'd have to know to go ask for it, but you could ask for it and you could get a copy of it potentially. They're a public record.
A letter of warning goes in the appraiser's file.
I think the records are maintained 78 years according to the state's Record Destruction Act, which is essentially
Did you say 7 or 8 or 78?
78.
78
Essentially,
years.
the record has to outlive the appraiser. Is the record destruction is to maintain past the point where the appraiser could possibly outlive it. So, yes, it is essentially in perpetuity as far as the appraiser is concerned.
I reckon part of my concern is, let's take the very first one. The neighborhood that's described on page 2 contains multiple neighborhoods. It probably describes the subject's entire market area. Well, the question then becomes, is the entire, market area what you describe as a neighborhood, or exactly what? And without seeing who did what, when, and where, I don't know whether that's right or wrong. The basement, 68%, I think that's been proven that there is a possible disagreement there. Highest and best use is stated, but was not summarized. Is this a residential report where all they have to do is add it's on a residential lot, so therefore it's residential? I don't know. A lot of these comments in here, of course, the one that really, I reckon, has got me going bad here is that the bullet point about the adjustment for gross living area. That one, I think, definitely needs to come out, at least part of it anyway. Quality of the data was not addressed. I don't know whether that's right or wrong. The applicability and relevance was not addressed. Don't know whether that's right or wrong. I'm just very concerned about putting stuff in these folks' file when I don't know whether it's right or wrong. That's my concern.
Was this can I ask a question? What type of report was this? Was this a form report or a narrative report?
Essential 1004-4.
Consequently, maybe we've been instructed to do this all along, and I just have not picked up on it. And if I haven't, then that's my bad. Nobody else is blamed but me. But if this is actually going back out, I don't want us to appear to be unknowledgeable. And if we agree to some of this stuff, it would appear to me that we're saying that we are not very knowledgeable people making decisions. I'd recommend we almost have to go down this thing bullet point by bullet point and almost vote yea or nay on every one from here on out to make sure that we're not sending out something incorrect. It's going to be long, it's going to be laborious, and I think, I don't know, there's got to be another way to handle these matters. I don't know, I don't have the answer, but I don't think this is the answer.
Practically speaking, we can't have the board members reviewing complaints. It was an inefficiency in the board that we just really cannot go back to. We used to have the board members review the complaint files, and when that happened, we were in excess of 100 open complaints at a time, and we also had complaints that were open for 3 years without being processed properly, because you guys are working essentially on your own time doing this stuff, and it's just not practical to do that. So we engage expert reviewers. You have the ability to agree or disagree with their findings. If you consistently disagree with the reviewer's findings, then Keeling has the ability to essentially fire a reviewer. But adopt it or don't adopt it, it's the commission's will on any of these points to decide these matters. If you don't think the appraiser has violated USPAP, that is for you to determine. But we just cannot go back to having individuals review these matters on a case-by-case basis, because it's too inefficient. If we have complaints that run over a year, now the ASC has the ability not only to sanction us with fines, but possibly to stop allowing us to certify and license appraisers until we get ourselves in line. These are additional powers the subcommittee never had before. I just don't think we want to create more inefficiencies. We finally got the complaints to a point where we are reviewing and processing complaints efficiently. If you disagree with a bullet point, recommend its removal. That's the way to go.
Yeah, I think I know this is difficult, but I feel like we're doing it the best way we know how to. I'm not sure at this point how we could do it differently and it be efficient. So if we need to go through these bullet points and take them out, and that makes you feel like we're doing what we need to do, then I don't have a problem with that. I just don't know what else to do without.
I would agree that we can't go back to having the commissioners, review these complaints. It's just too cumbersome. Doesn't work for the sake of the time limit. But I do understand Mr. Hall's concern. It is difficult to know from this, and that's no criticism of our legal representative, without having the report and the review. We're having to take a step of faith here with regard to the review report. And the neighborhood description, it seems to me, based on the type of report it is, that's kind of maybe a little bit over the top from the reviewer's perspective, but it's difficult to know without the report and the review report.
I think some of these bullet points could be subjective and may or may not should be in here. You have to rely on the local, and the reviewer may have no knowledge of that local market. Right. They may be going off of some geographical barriers, anything that the local appraiser may have a better handle on for neighborhood, that kind of thing. I think we're called on to make a judgment and use the best judgment that we can in the situation. I think I agree with Commissioner Hall that there are some on here that I completely disagree with the reviewer on, and their position on how they would develop an adjustment. But some of these, I think, in practice are just good common sense things to keep an eye on in any report.
Chair, I have a question.
Yes.
As counsel, and since you've provided them to us, when you're making the recommendation to close with a letter of warning, have you reviewed and or considered the disciplinary history in the past before you come up with that letter of warning?
Yes, and it's actually listed on the legal report, too.
Yeah, I see that,
Yeah.
but I'm asking because you have provided us with that information. So, agreeing with Mr. Hall that this individual, male or female, could be subject to something in the future based upon whether or not these bullet points are accurate or not. Okay.
Is the original appraisal report available to the members of the commission? Can it be made available?
Only in a formal hearing.
Okay.
Is it available at all to the public?
I'm sorry, can you say
at
what you
any
said
point in
again,
time?
please?
I just ask if the original appraisal report that the reviewer is critiquing is available to members of the commission to, kind of address the sort of questions that Mr. Hall raised.
Well, the only problem with that would be once you guys see it, then if for some reason it went to a formal hearing, then you would have to recuse and they're left to hear the hearing. But a letter of warning, I don't know if this is where you were going, is not a formal disciplinary action, like a civil penalty or something.
I understand that, but what I was thinking was that, you're not going to like this, if we ever had to have another attorney,
Right.
okay, and they looked at it and said, oh, in the past, this individual has suffered these improprieties, and they're doing it again, and the next time, maybe he did, to the west was Los Angeles, something absurd, that, I don't know, it could almost, looks like to me, it could be like a double jeopardy thing, that I really didn't do it the first time, even if I did the second time.
I think what you're saying is you're concerned that the letter of warning that's already in the file might be more of an aggravating factor if they get.
Exactly,
Yeah.
exactly, right. And if you're considering those before you make your letter of warning, if this letter of warning goes in, then the next council might say, well, they've had 3 letter of warnings, now let's take their license or whatever.
I don't think that it would have to be pretty egregious to go from letter of warning to take their license.
I'm just saying, but a more severe
But yes,
penalty then.
letters of warning can go into the aggravating circumstances for discipline.
But we do consider, like I said, we don't look at a letter of warning like, oh, you committed this, 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 and this. So it's really not gonna make something that comes after manifest into some crazy thing, because letter of warning, like I said, is not formal disciplinary action, and we're not saying, we think you did this, this, and this. We're just saying, be careful of this.
Can appraisers in the general public get a copy of that letter of warning?
Yes.
For the damage
Another
caused.
question. Would it be possible just to write the individual and say you have been made aware of the concerns? Items the commission would like to, rather than actually saying, we find you, quote, guilty of items bullet point 1, 5, and 6, and not guilty of items blah, 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 because I just do not feel that I have enough information in here. Place this in the file, so that if anything comes up in the future, if this person has to go to court and they get on the stand, I don't want an attorney on the other side saying, oh, Miss So-and-so, right here, it says, and the commission found that you did this. That's wrong. That is wrong. Now, I don't have the answer, and I'll admit that right up front, but this is wrong.
There's not any specific thing that it's like mandated to go into a letter of warning. So if you feel more comfortable with me wording it that way, I don't have a problem with that. If you feel more comfortable with me saying something like, you've already been notified of the notice of violations,
Right.
Found by the reviewer, however, the commission review caution you, and we don't put any of the bullet points in there, I don't have an issue with that.
I think I could live with that a lot better, personally.
Can I go back to another question that came up earlier? Under this situation here, what would, and Nicole referenced that they could get this, but it would be somewhat difficult. What's available to someone, say, later, 6 months or a year down the road? What with regard to a particular case here is available to the public, that's public information?
all the records in my office except social security numbers, which could be redacted from a file. Should there be any medical records and communication between the attorney, specific communication between my attorney and myself. Those records are specifically excluded. Everything else is accessible, considered public record, and anyone can ask for it and get a copy of it.
They could ask for the appraisal and the full review under the sunshine.
The appraisal, the review is not in my files. They're in the legal files, and they're not available to the public.
It really is attorney work product because I'm the client of the reviewer. So it would be, you know, you can't
They
just
couldn't
ask
even,
for
they
that.
couldn't get that.
Unless it went to formal hearing, in which case it became an exhibit to the hearing, and then you guys all saw it, everybody saw it.
They can't get it in, yeah, they can't get it unless it's in discovery or something like that. So a normal person just asking for it, they couldn't because it's attorney work product because the review report is done for me.
If there was a lawsuit, they could get it through discovery.
But essentially, they would have the same information that we have, and, you know, based upon what Mr. Hall was saying, they could be influenced by the same thing. Well, it says here, these are all these bullet points that the reviewer found, and I don't know.
Possible, it's not very probable.
Difficult issue, I understand.
It's not very probable.
It is difficult, and I think you have to look at it, I know that you have to look at the reviewer's conclusions as it says there. Those are also alleged violations. So we're not saying you did this, this, and this. I know what you're saying.
No, that's a good point.
Um,
I think that's important to understand. That
Right. It does say alleged
We're not saying we
in the bracket.
necessarily, right.
Right.
Okay, I agree with all those.
I think that wording is very important as to how it's the letter of warning or caution or whatever is written.
That is how they're written. I know
Is
that.
alleged.
Right. It doesn't say we found this, this, and this. It says,
I personally like the idea of not
okay.
including bullet points. 'Cause otherwise, we're going to have to go through every one of these things,
Right, you're right.
you know, and I just don't think that's appropriate either.
How often does someone come in and ask to review your files?
Exceptionally rarely.
I mean, once a year?
No, we get, I don't know, 9 or 10 a year, maybe.
Is
public
it,
records requests. Usually it's an attorney after some specific information, in some case, against an appraiser.
Generally, a lawsuit or a claim of some sort.
Normally, in my experience.
Yeah, it can be a lot of different reasons that somebody asks for something. It's usually the requests aren't for everything. Usually they ask for something specific, like all consent orders or all agreed orders. If you ask for everything, you wouldn't really. Then they're gonna probably end up paying for everything, and that's expensive.
I know that Mr. Standifer and I don't know about Randy, but I know we're heavily involved in court. And I have seen the depths to what these attorneys will go to try to discredit someone. And I want to try to protect the appraisers of the state of Tennessee from being subject to that type of cross-examination over a commission making a decision to do something without any more information we have.
Same
Is there
time,
something between a letter of warning and complete dismissal?
No, well,
letter of caution.
which is
But-
technically the same thing. You're just kind of using, like, instead of we're warning you, we're cautioning you. But if you wanted to make these all letters of caution, I don't have an issue with that either. We don't have to call it a letter of warning. I don't have to put letter of warning. I can say letter of caution. It really doesn't matter to me. It's whatever you guys think is more appropriate.
Well, I appreciate the sentiment of protecting the appraisers. The mission of the commission is to protect the citizens of the state of Tennessee. And if we have an appraiser who is, engaging in conduct that violates USPAP, and we don't even at least advise them that they're violating USPAP, potentially, and then we get repeated, and we just keep not
I mean, if we have to establish a policy or a pattern of the letters of warning, caution, instructions serve to go, okay, well, they've been advised not to do X, maybe we should discipline them so that moving forward, they don't do X. And if they continue to do X, then maybe it is time to suspend or revoke their license or suspend them or whatever is necessary to make sure that we are protecting the citizens of the state of Tennessee. That's what the commission is here for. I'm an appraiser too, and I certainly would want to be treated fair, but at the same time, that's not what I'm here for. So I'm just,
Okay. Chairman Walton?
All right, are we ready to?
To my understanding, there is no motion on the floor at this point in time.
That's correct. We've been in
So may I
discussion.
make one?
Is everyone said their piece? Are we done with discussion?
One last point. I think the flip side of what Nicole just referenced is also the overzealous property owners or lenders or attorneys as well. So I think there's a balance there.
definitely should be a balance, and the commission's will is always, that's why there's such a diverse voting structure to the commission. Whatever you guys decide, that's how it should be. But, you know, you have to keep the citizens of the state of Tennessee in mind when you decide these things.
Well, and I think Commissioner Hall's point is really more along the line, not protecting appraisers, but not unduly exposing them to liability.
And, I mean, what you're saying makes sense. I understand exactly what you're saying.
All right, does this conclude discussion? Is everyone?
I'm going to try out the motion. If anyone here doesn't think it's a very good motion, I have no feeling hurt if you said, wow, let me try that again, okay? I make a motion that Ms. write a letter, explain to this person that we have reviewed the complaint and that it's a lot in the future, words to that effect, but not to list each and every bullet point in that.
Probably just not going to list any bullet points. Because we've already received the notice of violation, so at this point, based on what you're saying, I don't really see it necessary.
Second.
All right, to clarify, we have a motion on the floor by Commissioner Hall for a letter of warning excluding all bullet points,
Let's just call it a letter of caution.
Okay.
letter of caution.
Yeah.
Are-
Are
And
you okay?
seconded by Commissioner McCara. Am I clear? All right, those in favor, say aye.
Aye.
Those opposed, by nay. And the motion carries. We're ready for case number 3.
Okay, item number 3, 2014-022301. This complaint was filed by an appraiser and alleged that respondent failed to submit payment for 5 unpaid appraisal invoices, where appraisals were completed 10/28/13, 10/30/13, 4/1/14, 4/1/14, and 4/17/14, totaling $1,800 in unpaid appraisals. According to TCA 6239-421, each appraisal management company shall, except in cases of breach of contract or substandard performance of services, make payment to an appraiser for the completion of an appraisal or valuation assignment within 60 days unless a mutually agreed upon alternative payment schedule exists from when the appraiser transmits or otherwise provides the completed appraiser or valuation study to the appraisal management company or its assignee. Respondent's attorney filed a response with the state stating that according to the statute, there are 2 exceptions to the prompt payment requirement, 1 being breach of contract or 2, substandard performance of services. In addition, the 60-day period does not begin to run until the appraiser transmits or otherwise provides the completed appraiser or valuation study to the appraisal management company. Respondent's attorney stated that respondent acted in good faith, and with regard to 2 of the instances complained of, checks were issued in a timely manner. Proof of those payments is included in the complaint file. Respondent stated that 2 of the appraisal orders were canceled due to appraiser tardiness and unresponsiveness. With regard to the other instance, the order was canceled when it was discovered the property type exceeded the appraiser's license. council contacted respondent and requested written documentation showing correspondence with the complainant on the cancellation of the above-mentioned appraisal orders. Such documentation was provided by respondent showing that complainant failed to submit the reports during the time frame requested by respondent, and thus the appraisal orders were canceled in writing. It is respondent's belief that the complainant may have violated USPAP on one appraisal order by offering to complete a commercial appraisal without the necessary license and competency and by not declining the assignment when it was discovered that the property type exceeded his license type and competency. For the recommendation, complainant did not provide any information sufficient to dispute the detail record provided by respondent in this matter. As such, council recommends that this matter be closed with no further action, as respondent has provided sufficient information to support that there was no violation on their part regarding payment for services in this matter.
All right, we've heard legal's recommendation. Is there any discussion on this case?
Uh-huh. It indeed should. Sorry. I read it the way it should be sounding. I just didn't. I caught it. But yes, it should be B.
All righty, any further discussion? Do we have a motion on this case?
So move.
Second.
Motion by Commissioner Hall, seconded by Commissioner Thomas. All those in favor signify by voting aye.
Aye.
All those opposed by nay. And the motion carries. And we're ready for case 4.
Okay, item 42014019881. This complaint was filed by a consumer and alleged that respondent did not report that there will be a 5-lane highway behind the house. Complainant feels that respondent took advantage of complainant's age when appraising the property. Respondent sent a response to the complaint stating he had no idea the road in question was being widened until he received a letter from the complainant after the appraisal was completed. Respondent stated he was engaged by a regional bank to do a market value appraisal of the subject property for the purpose of mortgage financing for the purchase of the subject property by the complainant. Respondent stated there were no survey markers, no spray-painted lines in the yard, no signs posted, and no kind of physical activity that road work was going to be done. Respondent stated that a veteran real estate broker had the listing of the subject property, and he made no mention of any road widening project in the listing. The complainant provided respondent with a project information sheet that TDOT gave them on June 13, 2014, stating that a public hearing on the widening was going to be held December 11, 2001, which was 13 years ago. Respondent stated he can understand why the complainant is looking for someone to blame because they are not happy about their purchase. However, respondent had no idea of complainant's age at the time of the appraisal and would never take advantage of an older person. Respondent stated he honestly did not have knowledge of the road widening at the time of the appraisal. There's just one reviewer conclusion listed there, and then the recommendation is the reviewer noted several reporting issues in their review. However, the only substantial issue noted was a failure to summarize the analysis of the current contract. As such, council recommends this matter be closed with a letter of warning relative to this reporting requirement, which we can change to caution if you would like. I'm just going to be consistent with these from now on, based on what we've decided, so.
All right, we've heard legal's recommendation. Is there any discussion on this? Hearing none, do we have a motion?
So move.
Second.
All right, we have a motion by Commissioner Thomas, second by Commissioner Hall. All those in favor signify by saying aye.
Aye.
All those opposed by nay. And the motion carries.
Okay, item 5, 2014020371. This complaint was filed by a consumer and alleged that respondent used incorrect comparable sales data, which caused the subject property to be undervalued. Complainant alleged the comparable sales used were homes that had no garage, were vinyl sided, and were not in an upscale neighborhood. Complainant alleged that you couldn't even build a home at the price respondent appraised the subject home. Respondent sent a response to the complaint stating that the client requires 3 comparable sales and 2 comparable listings be used, which have taken place in the prior 12-month period. Of the comparable sales used in determining market value, all 4 sales and 1 comparable listing had garages and 1 comparable listing had a carport. All 4 sales and 1 listing were brick and 1 listing was vinyl. All comparable sales and all comparable listings were in similar neighborhoods. Respondent stated in his response that the appraisal was to determine an opinion of market value and not the replacement cost. The reviewer's alleged violations are listed here. So if you want to take a minute to look at those, then we'll talk about the recommendation.
All right, has everyone had time to review the reviewer's finding on this case? I'd like to open the floor for discussion.
Question, did the respondent send a letter back in addressing any of these points that were brought up?
No, if it's not listed on here, then they didn't provide a response. I
They
mean,
were provided with the reviewer's findings, they just didn't respond.
right, they were provided with the notice of alleged violations by the reviewer, but they did not provide a response to those alleged violations in this matter.
I hear where the respondent sent a response, that was just to the letter
Right.
or the complaint
The
filed
first,
by the property
the first
owner.
response is the response
Okay.
to the initial complaint, and then they're given another chance to respond to the alleged violations by the reviewer. This person just did not do that.
Can I ask a question? When a while ago, you commented that you were the client of the reviewer. What's the instructions you give them when you just say review it?
Yeah, basically, it's just a standard 3 review, and they are instructed to try to address the complainant's allegations as well as to just note the USPAP violations.
The reason I'm asking that, it just seems to me like with his going into this floodplain, that has nothing to do with what the complaint was filed about. It just seemed like the reviewer's going
Right, well,
above and beyond, because I know a guy in Kentucky that does reviews, and I've talked to him intensively, and, man, he just eats everybody up for everything, whether it's relevant or not relevant.
Right, the reviewers, I mean, they don't just stick to only the allegations within the complaint.
We have a responsibility per appraisal subcommittee requirements that we not only review the appraisal for the complaint allegations, but we review them for USPAP compliance. So we have to review the complaint to see if review the appraisal to see if it complies with USPAP. So we review the whole kit and caboodle when we get an appraisal in. If there's an appraisal involved in the complaint, then we have to review it.
All right, is there any further discussion?
I just have a comment.
Mm-hmm.
And the trooper or the officer says, not only am I gonna give you a ticket federal government up there ought to stay in Washington and leave us alone. But that's another point.
Here's how I look at it, Mr. Hall. We're required to review it for USPAP compliance. Your determination is how much, or if any, discipline is warranted. But if our reviewer, using your analogy, sees a body in the back seat of that car that was just speeding, and he doesn't point it out, we haven't done our due diligence to tell you, okay, well, he was going 85 miles an hour and there was a body in the back seat, but we decided to only charge him with that speeding ticket because, we only technically knew that. So
what's the problem?
So what's the problem? Once we become aware of a violation, we have to communicate it to you. You're the judge and jury, essentially. Decide what is appropriate in this case.
And this was sent back to him or her, and they just didn't respond again?
Correct.
Okay.
And I will say, to me, that floodplain situation is significant. Even though it was misrepresented really in the report, it could possibly be an ethics violation. It wasn't identified as such. But to me, that's a fairly serious violation that could seriously impact the marketability
Go to highest and best use. It could be an
highest and best
issue.
use, everything about that property.
And I think it's important to keep in mind, too, that a lot of the complainants might be people like me that don't know that something was a problem.
Right.
I mean, if someone came to appraise my house, and I couldn't pick out everything that they did incorrectly, so I think that's important to remember, too.
All right, do we have any further discussion, or are we ready to entertain a motion?
I forgot to state the recommendation. Should I do that first?
Oh, yeah,
Okay.
do that.
The recommendation is the authorization of a 15-hour residential report writing course and a $500 civil penalty to be settled by consent order or formal hearing.
All right, we've heard the council's recommendation. Do we have a motion?
Move to accept.
I second.
All right, we have a move to accept by Commissioner McCara, a second by Commissioner Point. All those in favor, say aye.
Aye.
All those opposed by nay. And the motion carries.
Okay, item number 6, 2013011451. This is a representation. This complaint was filed by a consumer that is in federal prison for bank fraud and has alleged that respondent communicated an oral appraisal to a bank in a federally related transaction, which requires a written appraisal, and overvalued 3 commercial properties, which included 2 car washes and a strip mall. Respondent indicated he contemplated an appraisal of these properties in early 2006. He indicated he was engaged by the buyer and then referred to the lender for the financial data on the property. He indicated he tried several times to get the data from the bank. He indicated he did not tell them prior to closing any value because they had not provided financial data. He indicated a few days after closing he received the rental schedules and summaries for the shopping center and submitted a combined value for the 3 properties of $1,720,000. He indicated the buyer defaulted on the mortgage and the property sold at public auction for $1,500,000. He indicated a few days later that the loan officer asked him to do a business valuation of the properties. He said he did not have much confidence in the reported income statements, but he submitted an appraisal, but stated several times in the report, if any information I used in proved incorrect, I reserve the right to revise the report. He indicated several months later he was contacted by the FBI and they asked him to bring his files with him. He said he gave them a statement indicating he did not provide a verbal appraisal of $4 million, and other than the business analysis done after the loan was closed, he has not done any further appraisal work on the properties. He indicated he no longer has the appraisals or work files because the FBI took them. On June 18, 2013, Nicole Avers provided the respondent a copy of the appraisal, which was submitted with the complaint. The copy provided to the respondent was marked copy at the top of the appraisal report. The respondent indicated that he received a letter from the complainant also. Ms. Avers requested a copy of that letter. He stated in conclusion he believes his value option was reasonably accurate. This complaint was formally authorized for a formal hearing by the commission. However, the respondent had been ill for a number of months and after a period of time in hospice passed away in late October. So, as a result of that, I'm recommending that this matter be closed with no further action.
So moved.
A second.
Is there any discussion? Hearing none, we have a motion by Commissioner Hall, second by Commissioner Point. All those in favor say aye.
Aye.
All those opposed by nay. And the motion carries.
Okay, and the last item, number 7, 2012001291. This is also a representation. I'll just read what I normally read. The matter was previously presented in a formal hearing. As a result, a final order was filed on January 29th, 2014, which assessed a civil penalty in the amount of $200, along with investigatory and hearing costs in the amount of $3,760, for a total of $3,960 due and payable. The facts as presented at the December 2012 commission are as follows. The complaint was filed anonymously and alleged that respondent communicated a misleading and/or unsupported value opinion. The complaint included 2 reports on the same property completed by respondent on September 15, 2010 and September 18, 2009. Respondent stated in his response that the subject property appraised consisted of vacant land that was planned to be developed with condominium development. The developer had projected the construction of a clubhouse and other amenities for this development, but the respondent was never provided with any construction plans or details of the proposed clubhouse or other amenities. Because of this, any influence of amenities such as the proposed clubhouse, etc., was not included in the appraisals. Respondent stated the appraisal reflected the value assuming completion of the development and the value of the land assuming no development occurred. Respondent states that his appraisals are accurate and indicative of market value, whether the land was developed with condo pads or remained vacant and undeveloped. Values for either circumstance were included in the appraisal reports. And the reviewer's conclusions are listed there. You guys have already seen these. So I'm gonna skip down to the recommendation, and then if you have questions, you can stop me. In the previous recommendation, the reviewer found that the 2010 and 2009 reports do not provide results in an appropriate manner, do not contain sufficient information to enable the clients and intended users to rely on these reports to understand them properly. The reviewer also found a violation of ethics standard. Respondent has been the subject of disciplinary action by the commission in the past. So the council recommended authorization of a civil penalty in the amount of $1,000, along with a 30-hour course on general appraiser sales comparison approach and a 30-hour course on general appraiser income approach. So that was what was authorized at the past meeting. So the new recommendation is, this office received a $3,500 payment from respondent in early October, and that's October of this year. Respondent passed away in late October of this year. The outstanding balance on the final order is $460. Due to respondent's death, the $460 is now uncollectible. As such, council recommends this matter be closed as paid.
All
So
right.
move.
All right, is there any discussion? No discussion. We have a motion by Commissioner Hall, second by Commissioner Thomas. All those in favor indicate by saying aye.
Aye.
Those opposed by nay. And the ayes have it. And I believe that concludes the legal report.
Yes.
All right. Would the commission like to, the next thing on the agenda is lunch, but
Just a quick new business item, and I think that's it, unless anyone else
All
has
right.
something else.
is everybody in favor of pushing on for the new business, and then we could
Yes.
adjourn?
We got out the newsletter. I hope everyone got a chance to see it. I passed out a color copy of it, and just in case anyone didn't get it in their email, you can sign up for future editions of the newsletter on our website. Cody Kemmer is our staff-in-chief for newsletter distribution and writing. I'm hoping that you will all consider volunteering articles for future editions of the newsletter. He's going to try to do interest piece on each of you, one at a time. So if you want to volunteer to be next, please do so. If you have topics you want covered, please let us know. We can research the topic and get it into the newsletter. I think this will be.
I'd like to commend you for a really good job on that. Thank you. That takes a lot of effort, and I think it's a really good addition. Good.
A lot of comments back on it. It's a much improved newsletter, so.
Unless you want me pouring through your personal life, submit an article, then we won't have to.
Scoop.
Then we won't have to talk.
We've got some other changes on the horizon. We're going to be transitioning to a new license system here in the next few months. And we've got the fingerprint background check thing kicking in January 1st. So next month, we have a formal hearing that's scheduled to happen. I don't see any. That's it for.
Question.
Mhm.
I mentioned. What you gotta do in order to get your fingerprints, or is that? Submit your fingerprints in that.
The law does not encompass renewals. It's only for initial applicants, so only people applying for the first time or applying to upgrade would have to get fingerprinted, right? So, if you got any secrets, it's not you. I know you're all kidding, so let's put that on the record. I know you're all kidding. But no, it's just on initial applicants, so trainees or people upgrading their license will have to do a background check.
How that might work. Okay.
And that'll be included in their application package.
I have a question. Have you done anything, and I know you've had so much going on, you probably haven't, about some training for the commissioners from someone concerning improving ourselves? We had talked earlier, a couple of months ago, about maybe getting Mr. Disney from Kentucky to come sometime and do a little training with us.
Not specifically on that front. We've had different board member trainings on, like, ex parte communication and all that kind of stuff. We've had several different board member trainings come along. If you mean as far as USPAP, the foundation is going to be issuing a USPAP for regulators, which is, I think, going to be 4 hours long. That should become available sometime in 2015. I didn't think that you all wanted a 7-hour USPAP course in addition to what you do here, and then you get to do it on your own too. So, no, I hadn't specifically anticipated inviting Larry Disney down. We could, but you already have so much board business to do. One of the things I'm looking at doing for 2015, and I'm hoping I don't hear a lot of objection to this, is after January, maybe going to every other month. Instead of having to meet every month, maybe every other month. And if we can continue this pattern of reduced complaints, maybe even quarterly. That would be subject to us being able to maintain low complaint numbers. We certainly don't want to get back into hot water again with complaints. In January, we have the subcommittee coming to do their biannual audit of us. And so that's going to be intensive for us as the staff of the commission. They ask for a lot. And not to mention the fact that right at the same time we're going into the new rule changes and fingerprint background checks and all of that going on at the exact same moment. So the next 60 days is going to be a lot for us. But you guys want some more professional improvement things, I could look at it again maybe March or later.
Is the meeting in December going to be a 2-day meeting?
We only have 1 day on the book for December. We have 2 days in January.
Okay.
1 day in December, 2 days in January. We have that 2 days because of the subcommittee.
Do you think we'll meet in February?
It's on the books right now. I'm not overly optimistic.
Do you have the schedule for next year? Has that been published yet?
It's posted
Is it
on the
online?
website.
Okay.
Yeah.
Well, if we go to either every other month meetings or quarterly meetings, do you anticipate that they would be more than 1-day meetings each?
No.
Okay.
No. I don't expect it to be.
Trade-off there, we meet less frequently, but.
No, I expect that the meeting would be essentially the same. Right now, we're at a very good, as you saw in the director's report, we're at very good complaint numbers right now. If we can just get through these formal hearings that we have on the books, we'll be in a very good place.
Just because I'm the rookie and don't understand quite yet, what's the board's policy on anonymous complaints?
As long as it comes in writing, contains a respondent, identified appraiser, and specific allegations that can be investigated, we accept anonymous complaints. Essentially, they become a complaint of the commission. Like, this has been alleged, we look into it, and we treat it the same as any other complaint. Not enough to go on, we don't have anyone to go back to. So if the information submitted wasn't complete, that happens very occasionally. Usually it's pretty well grounded. If the information were to be incomplete, then we wouldn't process it as an open complaint. Like if they left out the name of the respondent. We got one recently where someone just mailed in 5 appraisal reports and said, each of these 5 appraisals have different square footages, and they didn't name a respondent, and they didn't say what I don't have enough to go on. Pick something, so that would not be an instant of, let me process a complaint for you. But many times
I believe the anonymous complaints are professionals that are trying to submit information to the commission without the fear of retribution.
All right. Is there any further discussion? Make a motion that we adjourn.
Yes.
Second.
All right, we have a motion by Commissioner Hall, second by Commissioner Johnson. This meeting of the Tennessee Real Estate Appraisal Commission stands adjourned.